takes various sessions on these aspects, and he has been a professor in the in the Manav Rachna University as a professor and the director of that. Coupled with the fact that his resume itself would reflect on various perspectives that his main forte is the arbitration. And since ADRs of late has picked up, and issues which normally keep on come up and prop up, as we say, for debates, and to all these gray areas, if not black, I can say that if you hear it from a person who is well versed with these aspects, I'm quite sure that the clouds of doubt which are in the mind of a common man or a professional who is trying to learn the nuances, they would be dispelled with. Without taking much time, I would request Ajay Thomas, an advocate and independent arbitrator who's a member of the ICC Committee on Arbitration and ADRs, and also the past vice chairman of the Paris-based ICC Court of Arbitration India Arbitration Group, to take things forwards and share his insights, and on at least in Chandigarh, it's a cloudy day, to bring the sunshine on this thought process. Over to you, Ajay.
Thank you, Vikas, for your very kind invitation, to be speaking on the topic, or rather a larger, broader topic, which has been the source of certain controversy in recent times. I wouldn't say controversy. I think the right term would be there has been debate on it in different times, because there is a certain lack of understanding as to what are these two basic concepts. And the two concepts that I would attempt to shed some light on today, in light of the manner in which the law relating to these two concepts has evolved in India in recent times, is the two concepts of seat of arbitration and venue of arbitration. So, ladies and gentlemen, Vikas suggested that I should probably not be using slides, but those of you who know me well will know me and refer to me as Ajay PowerPoint Thomas or Ajay PPT Thomas. And that, ladies and gentlemen, is due to the fact that I usually never make a presentation or a speech without the aid of PowerPoint slides. And that's exactly what I'm attempting, what I'm going to be doing today, is I am going to be illustrating my thought-sharing experience on these two concepts with you with the prop of PowerPoint slides. So permit me to share my screen and my slides with you. All right. Now, Vikas, could you please confirm whether my slides are visible? Could any of the organizers confirm that my slides are indeed visible?
It's fine.
Okay, excellent. Thank you, Vikas, for the confirmation. So, ladies and gentlemen, let me begin my presentation by giving you an insight into this concept of seat and venue of arbitration. So when we are looking at these two concepts, I will attempt to look at the definition of the concept of seat of arbitration first, because that, I believe, is a more important concept which has got legal consequences vis-a-vis the other analogous related concept of venue of arbitration. So, ladies and gentlemen, what exactly is the seat of arbitration? Now, we must remember that arbitration doesn't operate or function in a legal vacuum. Arbitration is a process of dispute resolution which, although it is an alternative to a court of law, it is intrinsically linked and derives its legitimacy and its legality from the courts of the law of the land, and from a statute which is there in almost every jurisdiction called the arbitration law. So, it is very, very important to understand that arbitration doesn't function in a vacuum. It needs the support of the public justice system represented by the courts to give it effect and legality. And the seat of arbitration can be defined as the primary legal jurisdiction to which an arbitration is anchored in or attached to. So that is the conceptual definition of this concept of seat of arbitration. So seat is important because it gives legitimacy to the arbitration, it gives legality to the process of arbitration, and also it determines the nationality of the arbitration and the consequent award. And this importance, or the real importance of this concept of seat of arbitration and the paramount role that it plays in this process of arbitration has been highlighted by the Honorable Supreme Court of India in that landmark decision, that constitution bench of the Supreme Court decision in Bharat Aluminium versus Kaisar Aluminium Technical Services. Now, ladies and gentlemen, you will remember this 2012 decision was perhaps one of the most important decisions in recent times emanating from the Supreme Court of India, for the sheer fact that this decision signified, in my view, a self-correction which was attempted by the courts in India, and it reflected a change in the manner in which courts looked at the process of arbitration. So here we find with the Bharat Aluminium Kaisar Aluminium case, better known as the Balco case or the Balco decision, I think the Supreme Court turned a new leaf when it comes to this, its attitude towards the process of arbitration. Here we see that courts attempting to have a hands-off approach, a non-interventionist approach to arbitration, vis-a-vis the more interventionist approach that it had prior to the Balco decision. And in the Balco decision, the Supreme Court highlights and clarifies the seat of arbitration as follows. And I quote the Balco decision. It is accepted by most experts that in most of the national laws, arbitrations are anchored to the seat, place, or the situs of the arbitration. And then the Supreme Court goes on to quote para 3.54 of a book which is considered to be the most important and widely read commentary on international commercial arbitration. That is Redfern and Hunter on international commercial arbitration. And quoting this book, the Supreme Court goes on to conclude that the seat of arbitration is thus intended to be the center of gravity. And that is the reason, ladies and gentlemen, today I'm here today before you, talking to you about the importance of this concept of seat of arbitration, and also looking at how it differs from a related concept of venue of arbitration. And what I will also attempt to do today is to give you an insight into certain recent decisions of the Supreme Court of India, which has interpreted these two terms, that is the seat of arbitration and the venue of arbitration. I'm given to understand that I have all of 35 minutes to make my presentation. So I will attempt to make it as brief and interesting as possible. So ladies and gentlemen, seat of arbitration, I think there is conceptual clarity now as to what is this concept of a seat of arbitration. And what is the significance? We've defined the concept of seat of arbitration. Now it will be very important for us to understand the significance of this concept of seat of arbitration. Now, seat of arbitration is important, in my view, for three broad reasons. One, it fixes the lex arbitri, or the law governing the conduct of the arbitration. And the law governing the conduct of the arbitration sets out the broad framework for the conduct of the arbitration proceedings. Secondly, the law of the seat of arbitration. The seat of arbitration is important because it decides, very importantly, which courts can have the supervisory and supportive jurisdiction of the arbitration. And in the recent past, there have been decisions of the Supreme Court of India which have equated the seat of arbitration to the concept of an exclusive jurisdiction clause which you would find in litigation. So seat, to a large extent, now has been equated to by a plethora of Supreme Court decisions to be equated to a exclusive jurisdiction clause. And finally, ladies and gentlemen, the third great significance of this concept of seat is the fact that it determines the nationality of an award. And this is very, very important from the perspective of international arbitration, because nationality determines whether you can enforce an award through the aegis of the New York Convention of 1958 or not. So these are three broad, significant factors why it is important to choose a seat of arbitration, choose it correctly, and the importance that this concept plays in the whole arbitration proceedings. Now, we saw that one of the significance of the choice of a seat of arbitration is that it decides the law that would apply to the conduct of the arbitration. And ladies and gentlemen, that law which would apply to the conduct of the arbitration is called the governing law of the arbitration. Its technical term is known as lex arbitri. It is also known as the law of the situs, and at times the curial law, and many a times it is also wrongly called the procedural law. We will also see as to why it is wrongly called the procedural law, because there is the possibility of having a procedural law which is different from the lex arbitri, or the law of the arbitration seat. And ladies and gentlemen, we must remember that the law of the arbitration seat is not a matter of choice. Let me emphasize this. The law of the arbitration seat is not a matter of choice of the parties. It automatically flows from the choice of the seat of arbitration. So the moment you choose a particular jurisdiction as a seat of arbitration, the law of the arbitration seat, or the lex arbitri, automatically flows from it. So assuming that you have chosen Singapore as your seat of arbitration, the choice of Singapore as a seat of arbitration would automatically infer that the arbitration laws of Singapore would automatically apply to the conduct of the arbitration proceedings. So if you want to read Redfern and Hunter on international commercial arbitration, Redfern and Hunter has tried to explain this concept of seat and the law of seat of arbitration by giving an example of an English motorist, an English car driver. You know, in England, cars, they drive on the left-hand side of the road. So he gives an example of an English motorist who travels across the English Channel to France. And the moment he goes to France, ladies and gentlemen, he does not drive anymore on the left-hand side of the road, but he will have to drive on the right-hand side of the road. So what Redfern and Hunter are similarly saying is that no matter where you are from, what is the origin or where are you based, in an arbitration, if your seat of arbitration is in France, then your driving will have to be on the right-hand side of the road. You have no option. As an Englishman in France, you cannot drive on the left-hand side of the road as you would drive in your own home country. So the moment you're making a choice of a particular seat of arbitration, the arbitration laws of that particular seat of arbitration would automatically apply to your arbitration. You have no choice when it comes to especially the mandatory provisions of the arbitration law of the seat of arbitration. So that is something that you need to very clearly remember and understand, that the law of the seat of arbitration is not a matter of choice. It automatically flows from the choice of the seat. And why is the law of the arbitration seat important? It is important, ladies and gentlemen, because it deals with a whole lot of matters relating to the conduct of an arbitration. The law of the arbitration seat firstly determines the arbitrability of disputes. It determines the default appointment and challenge procedure for arbitrators, the duties and powers of arbitrators. It also very importantly decides the level and type of assistance that the courts can grant to parties in an arbitration. For example, the law of the arbitration seat decides the power of the court to assist, to order discoveries and injunctions. It also deals with, very, very importantly, with the process of judicial review of awards. Because we must remember that one of the most important roles that the courts of the seat of arbitration play is that when an arbitration award is given and a party wants to challenge that award or make an application for setting aside that award, application would necessarily have to be made to the court of the seat of arbitration. And that is important. Therefore, it is important, ladies and gentlemen, to understand as to what grounds are available to you in the law of the seat of arbitration, which you could use to set aside an award. So the scope of the interference or the support that the judiciary or a court can play in the process of arbitration to a large extent is determined by the law of the arbitration seat or the lex arbitrii. So, ladies and gentlemen, this is the significance of the law of the seat of arbitration. And let me come back to one of the most important factors which the seat of arbitration plays. I had talked about the nationality of the award. I had said that, I had alluded to the fact that the choice of the seat of arbitration decides the nationality of the award. And I also alluded to the fact that it becomes very important from the perspective of enforcing an award under the New York Convention of 1958. So, ladies and gentlemen, I am given to understand that there are a lot of students in the audience, and therefore it would be important for me to also be explaining certain basic concepts relating to the process of arbitration. And one basic convention that applies to the process of arbitration is this convention called the New York Convention of 1958, which relates to the cross-border recognition and enforcement of foreign arbitral awards. And ladies and gentlemen, this is an example of one of the most successful conventions till date of the United Nations in the realm of international business laws. 166 countries out of the 193 UN members are signatories to the New York Convention. Now, courtesy Norton Rose Fulbright, what you see on your screen is a map of the world showing you the extent of the spread of the countries which have ratified the New York Convention. So the countries in gray have ratified the New York Convention. The countries in red are yet to sign and ratify the New York Convention. So you will see that more than two-thirds of the countries in the world are already signatories to the New York Convention. Save and except for a few of those jurisdictions in Africa and a few in Asia, almost all the rest of the major jurisdictions in the world are signatories to the New York Convention. And therefore, it is very, very important, ladies and gentlemen, to understand this concept of nationality of an award. And nationality of an award, ladies and gentlemen, is determined purely by the choice of a seat of arbitration. And this is also very important from an Indian context, because when India signed up to the New York Convention, it entered two reservations. One is called the Commercial Reservation, and the other one is called the Reciprocity Reservation. So what it effectively meant is that when India signed up to the New York Convention, it said that it would only recognize awards which are commercial in nature. That's the Commercial Reservation. And it also further additionally said that it would only recognize those awards from countries which are gazetted by the government of India as reciprocating New York Convention territories. And that is called the Reciprocity Reservation. So, ladies and gentlemen, two reservations were entered into when India got into and signed up the New York Convention: the Commercial Reservation and the Reciprocity Reservation. And the reciprocity, under the Reciprocity Reservation, if India is to recognize an award from another New York Convention country, or another country which has signed up to the New York Convention, that country would have to be gazetted by the government of India. And this is very important from an Indian perspective, because till date, the government of India has notified or gazetted only 48 countries. Remember, there are 193 countries who are members of the United Nations, of which 166 are signatories to the New York Convention. But out of the 166, the government of India has gazetted only 48 countries till date. So what that effectively means is that for the rest of the countries, other than these 48 countries, if you want to enforce an award from those jurisdictions in India, you will not be able to do it to Part 2 of the Indian Arbitration Act and through the aegis of the New York Convention. You will have to get that award to enforce it in India, bring it to India, file a civil suit on it, and then get it enforced and executed. So that's a very laborious and cumbersome mode. So that is why it is precisely for this reason, ladies and gentlemen, that this point of nationality is very, very important from an Indian perspective. So when you're making a choice of a seat of arbitration, and if there is a possibility that you'll have to enforce that award in India, then it is very important to capture these 48 countries which have been gazetted by the government of India. Because otherwise, if you make a choice of any other seat, it will be very difficult to get that award to India and enforce it under Part 2 and the New York Convention. So that is why, ladies and gentlemen, again, seat is important, because seat determines the nationality of the award. Now, we must also remember that when we're looking at the concept of seat, you will also find a reference to the term place of arbitration. So many a times, the question is asked, is the concept of place of arbitration and seat of arbitration, are they the same? Are they different concepts? Well, my understanding from the reading of commentaries on arbitration and the statutes of major jurisdictions is that the term place of arbitration and the term seat of arbitration are analogous concepts. They are identical concepts. They are the same, and they must be used interchangeably. And for this, ladies and gentlemen, to understand this as to how and why I believe that these terms are the same and they are interchangeable terms, we must look at certain statutes. We must look at certain legal instruments on the basis of which countries have based their respective national arbitration legislations. So when you're looking at this, ladies and gentlemen, our first port of call would be the UNCITRAL Model Law on International Commercial Arbitration of 1985. Now, what exactly is the UNCITRAL model law on international commercial arbitration? As the name suggests, a model law is a framework for arbitration in
Yeah, Mr. Ajay.
So, because can I confirm you can hear me?
Yeah, it's perfect.
Okay. So, ladies and gentlemen, my sincere apologies. There's been a technical problem from my end, and as a result of the electricity going off here, I I do not have access to my computer anymore. So I'm attempting to join you through my phone. So till the lights come on again, you will have to do with just my voice and not the video and the slides. So I was talking about the UNCITRAL model law, ladies and gentlemen. The UNCITRAL model law was adopted by the UNCITRAL, which is the United Nations Commission on International Trade Law in 1985, as a recommended template for countries when they are going about drafting and crafting their own domestic arbitration laws. So the model law is only a template. It has no independent force of the law. So that is why when we're looking at this concept of seat of arbitration and venue of arbitration and place of arbitration, it would be very important to see what the model law says, because more than 90 jurisdictions in the world have based their national arbitration statutes on the UNCITRAL model law. It's a pity I can't show you. I have a map of the world with the countries which have based their jurisdiction, based their national legislation on the model law, and those which have not. But sadly, that I'll have to wait for another day. But we must remember that more than 90 jurisdictions out of the 160, after the 166 signatories to the New York Convention, have based their national legislation on this UNCITRAL model law on international commercial arbitration. And therefore, our first port of call when we are looking and analyzing this concept of seat, place, and venue of arbitration would be to look at what is the definition of arbitration in the UNCITRAL model law. And for that, ladies and gentlemen, it would be very important to understand the definition of given in Article 20 of the UNCITRAL model law. Article 20 of the UNCITRAL model law deals with the concept of seat, place, and venue of arbitration. So, ladies and gentlemen, you will have to allow me. Thankfully, mercifully, the lights have come on again, and I will attempt to join you with my slides in a minute. So just permit me to do that. Just checking.
Yeah, it's fine, Ajay. But you will have to keep the mobile at a distance.
Sure, I'll do it. Let me attempt to do it.
Or you can switch off the mobile.
Permit me to do that. Are we on again? Yeah, thank you so much. Thanks a ton, Vikas. Ladies and gentlemen, again, sorry for this interruption. These are the pitfalls of actually doing a webinar that the success of a webinar, the uninterrupted flow of a webinar to a large extent is dependent on certain basic things like electricity and your broadband being available. And sadly, where I am currently based, I don't think I can take that for granted. So anyway, let's proceed now with the concept of place of arbitration is defined in the UNCITRAL model law. Now, Article 20, ladies and gentlemen, defines the place of arbitration. Now, if you were to look at Article 20, it says it does not use the word seat of arbitration, but it uses the word place of arbitration. And it says the parties are free to agree on the place of arbitration. Failing such agreement, the place of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. And then it goes on to say, notwithstanding the provisions of para 1 of this article, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation amongst its members, for hearing of witnesses, experts, or the parties, or for inspection of goods and other property or documents. So if you see here, ladies and gentlemen, the UNCITRAL model law, which is the basis of the arbitration laws of almost 90 jurisdictions, does not use the word seat of arbitration, it uses the word place of arbitration. The Indian Arbitration and Conciliation Act of 1996, to a large extent, is derived and based on the UNCITRAL model law on arbitration.
But if I post something that might not be like nice, and if I tag beyond
Yeah, tag them.
Is there a problem, Vikas? Okay. All right. So, ladies and gentlemen, as I was saying, the UNCITRAL model law, Article 20, has been the basis for the national legislations and the definition of place of arbitration in almost 90 jurisdictions around the world. The Indian Arbitration and Conciliation Act, the definition of place of arbitration is to a large extent identical, save and except for the fact that the content is divided into 3 paragraphs instead of 2 paragraphs as given in the when compared with the UNCITRAL model law. But otherwise, it's almost an identical reproduction of the Article 20 in the UNCITRAL model law. If you look at the Singapore International Arbitration Act, again, Article 20 of the Singapore International Arbitration Act is identical to the model law, because the International Arbitration Act in Singapore wholly adopts the model law into its own legislation. In fact, if you read the Singapore International Arbitration Act, Schedule 1 is a reproduction of the UNCITRAL model law. And if you look at the Singapore Arbitration Act, Section 2.1 also goes on to talk about, to a certain extent, define the concept of place of arbitration. And it uses the word place of arbitration to a large extent because it has adopted the model law and the exact language given in the model law. And it says that the place of arbitration means the juridical seat of arbitration designated by the parties to the arbitration agreement, any arbitral or other institution or persons authorized by the parties, or the arbitral tribunal as authorized by the parties. So here you have the definition of place of arbitration given in the Singaporean Arbitration Act itself. We do not in India have the place of arbitration defined in any provision of the Indian Arbitration and Conciliation Act. And then, ladies and gentlemen, it's also very important for us to look at Section 3 of the English Arbitration Act, which uses the term seat of arbitration and not place of arbitration. If you look at the language and the text of Section 3, it is to a large extent very similar to Section 2.1 of the Singaporean Arbitration Act. The only difference is that it uses the word term, or uses the word seat of arbitration instead of the word place of arbitration. And another thing that you need to keep in mind, ladies and gentlemen, is that England is a rare exception of a country, of a leading arbitration jurisdiction, which is not a model law, United Nations UNCITRAL model law country. In other words, the English Arbitration Act of 1996 is not based on the UNCITRAL model law. So in that way, England is different from 90 other jurisdictions around the world who have based their arbitration statutes on the model law. So ultimately, at the end of the day, ladies and gentlemen, the inexorable conclusion that we come to is that the terms place of arbitration and seat of arbitration are used interchangeably, but the use of the term place, in my opinion, is actually preferred because of three reasons. One, I believe the word seat of arbitration more accurately defines the nexus between territorial attachment and the applicable procedural law. Secondly, it also reduces the scope for confusion with the concept of venue, location, and place of hearing of the arbitration. And because of these advantages, ladies and gentlemen, you will see that certain arbitration institutions have, in their recent editions of their arbitration rules, replaced the word place with seat of arbitration. And a classic example of one of the rules in which this is done is the SIAC rules. The SIAC rules, when it moved from the second edition to the third edition, knocked off the word reference to the word place and replaced it with seat of arbitration. Now, ladies and gentlemen, we've seen what is seat and place of arbitration on one hand, and now we need to very, very quickly differentiate seat and place on one hand with the term venue of arbitration. Now, seat, as we saw, refers to the legal place of arbitration. It's a legal construct, whereas venue, to a large extent, refers to the physical place where the arbitral proceedings are conducted. In other words, it's a physical location of the arbitration. So the choice of a venue usually has got no legal implications. That's the general rule. But the choice of a seat of arbitration always has legal implications flowing from that choice. And that is why we need to understand and appreciate that the general rule is that there is a difference between seat of arbitration, venue of arbitration. One is a legal concept, one is a non-legal concept. But there are certain circumstances in which the courts have held the venue to be the seat of arbitration. And that is also something which will be the focus of my presentation today. So, ladies and gentlemen, when you're looking at the difference between seat of and venue of arbitration, one very important case is a Singapore Court of Appeal case in PT Garuda Indonesia versus Bergen Air. Now, this is a 2002 decision, and the object or the source of dispute, ladies and gentlemen, was a DC-10 aircraft, what you see on your screen, which was leased by Bergen Air to Garuda Indonesia. Now, Bergen Air is a Turkey-based company, and Garuda Indonesia is the national airline of the Republic of Indonesia. So there was a contract, there was a charter or a lease of an aircraft where Garuda leased an aircraft from Bergen Air for the purposes of conducting multiple flights from Jakarta, Indonesia to Saudi Arabia, to Jeddah, for the purposes of ferrying Hajj pilgrims. So there was this lease of an aircraft. Disputes arose out of this, out of this lease, and the matter went to arbitration. The clause said that the seat of arbitration shall be Jakarta, Indonesia, and the arbitration rules would be the ICC rules. So, ladies and gentlemen, sometime in 2001, there was certain civil unrest and disturbances in Jakarta, as a result of which the arbitration proceedings could not be held in Jakarta, and the tribunal, in consultation with the parties, moved the arbitration from Jakarta to Singapore. Now, hearings were held in Singapore, a decision came to be, award came to be rendered, and what happened is the award went against Garuda Indonesia. Garuda challenged the award in the Singaporean High Court. And that is how this matter came to be heard. Now, the Singaporean Court of Appeal held that in this case, it was only the venue of the arbitration that was shifted to Singapore. The seat of arbitration continued to be Jakarta, Indonesia. So the center of gravity of the arbitration continued to be Jakarta, Indonesia. Merely because the venue was shifted to Singapore, that did not mean that the seat had also shifted. And there was no contrary indicator to show that the seat of arbitration had also shifted from Jakarta to Singapore. And therefore, the Singaporean Court of Appeal refused to interfere and hear that application for setting aside the arbitration. It said that the correct seat of arbitration would be Jakarta, Indonesia, and to challenge an award and to set aside an award, one would need to go to the seat of arbitration, the courts of the seat of arbitration. That is Jakarta, Indonesia. So, ladies and gentlemen, this is a very important case, I would say, not an Indian case, but a Singapore case, which brings out this classic distinction and differentiation between these concepts of seat of arbitration and venue of arbitration. Now, this difference between seat and venue finds mention in Section 20 of the Indian Arbitration Conciliation Act, also in the rules of various international arbitral institutions. Look at the ICC rules, the SIAC rules, all of these have references to this differentiation between seat and venue of arbitration. So generally, ladies and gentlemen, if you're looking at these two concepts, the general rule is that seat and venue are not synonymous concepts and they cannot be used interchangeably. But there are certain exceptions to this general rule. And the first exception, ladies and gentlemen, which I will be looking at would be a certain line of cases of the Supreme Court of India where the venue was held to be the seat of arbitration. Then I will very quickly look into a certain line of cases where the venue was not held to be the seat of arbitration. And with this, ladies and gentlemen, I believe you'll get a fair understanding of this basic difference between seat and venue, and in what circumstances venue could be read to be the seat of arbitration. So, given the interests of time, ladies and gentlemen, I'm going to skip a few slides. Vikas, could you confirm how many more minutes do I have to say what I have to say?
As long as you can continue.
Okay, excellent. Thank you, Vikas. Thank you for that indulgence. So, ladies and gentlemen, let me start off with the first line of cases where the venue of an arbitration was considered to be its seat. Well, let me start off with an English High Court decision. I'm not starting off with a Supreme Court of India decision. I'm starting off with this case, Shashwa versus Sharma. It's a 2009 decision of the English Commercial Courts, High Court. Now, if you look, when you're looking at a case, and especially from a seat and venue perspective, it's very important to start off the analysis by looking into the arbitration clause. So when you're looking at the Shashwa versus Sharma arbitration, ladies and gentlemen, the arbitration clause in the agreement read as what is given on your screen. So if you were to pay 10 seconds and read the clause, you will find out that this is an arbitration clause under the rules of the ICC Paris. It says that the language shall be English, the venue of the arbitration shall be United Kingdom, and then it goes on to say that the governing law shall be the laws of India. So you see, there is a reference to the venue of the arbitration, but there is no reference to the seat of arbitration. The clause is silent with respect to the seat of arbitration. And this is what the English High Court held. Lord Justice Cook said in his decision that although venue was not synonymous with seat, the clause in this case provided sufficient evidence to satisfy the court that London was indeed the juridical seat of the arbitration intended by the parties. And then it goes on to say, Lord Cook goes on to say, when there is one, a designation of the arbitration venue as London, and two, no designation of any alternative place as seat, and three, combined with a supranational body of rules, i.e. the ICC rules governing the arbitration, and four, no other significant contrary indicia or indicators. Lord Cook was of the view that the inexorable conclusion is, to my mind, that London is the juridical seat and English law the curial law of the arbitration. So, ladies and gentlemen, this four-pronged test which was laid down by Lord Cook in this decision Shashwa versus Sharma of 2009 is what has come today to be called the Shashwa principle. And this is important. The Shashwa principle, ladies and gentlemen, is important because in India, this principle, although being a decision of the English High Court, it was quoted with approval for the first time in that 5-judge constitution bench of the Supreme Court of India in Bharat Aluminium versus Kaisar Aluminium, the Balco decision of 2012. It was also quoted and reaffirmed in Enercon versus Enercon, 2-judge Supreme Court decision. Again in Roger Shashwa versus Mukesh Sharma, 2-judge 2017 Supreme Court decision. And most recently in the 2019 3-judge decision of the Supreme Court in BGS SGS Soma versus NHPC. So that is why, ladies and gentlemen, I start off this discussion with an insight into what is this Shashwa principle. So from Shashwa, ladies and gentlemen, we now move on to a case which involved the transportation of coal from Indonesia to India. It dealt with a time charter party for the hire of a bulk carrier. A bulk carrier is a ship for the transport of coal from Indonesia to India. And many of you might be aware that India is the largest importer of coal from Indonesia, or rather, the largest exports of coal from Indonesia come to India. India has even overtaken China to be the largest importer of Indonesian coal. So, ladies and gentlemen, this case talking about the import of coal and the time charter party and the transportation of coal from Indonesia and China is this case of Harmony Innovation Shipping versus Gupta Coal India. It's a 2015 Supreme Court decision. And as usual, ladies and gentlemen, it would be very important to look at the clause in this case. What you have on your screen is the arbitration clause from which this dispute arose. Just pay us a couple of seconds to read and understand this clause. So, ladies and gentlemen, you will see from this clause that parties had provided for arbitration in London, but had not indicated whether London was the seat of arbitration. And what did the Supreme Court hold in this case? Now, the Supreme Court held that considering all the additional factors, it came to the conclusion that London, although it was not the seat of arbitration, was intended to be the seat of arbitration, and Part 1 of the Indian Arbitration Act was excluded. And it held that London was the seat of arbitration because the arbitration clause said that the arbitrators were to be the members of the London Arbitrators Association. The contract was to be governed by English law. And thirdly, it said that because there was a reference to the small claims procedure of the London Maritime Arbitration Association, or the LMAA, the seat of arbitration in this case was London and not any other jurisdiction. So this is a classic case, ladies and gentlemen, in that line of decisions where the venue of an arbitration, in the absence of the seat, express mention of the seat was considered to be the seat of arbitration. The next case, ladies and gentlemen, very important case, and I think to a large extent this case, if you were to read this decision of the Supreme Court of India, 3-judge bench of the Supreme Court of India, it lays down the entire Ram Kahani with respect to this differentiation between seat and venue of arbitration and the implications and purport of these two concepts. And this is a case which relates to the construction of a dam and a hydroelectric power project on a tributary of or a feeder river to the Brahmaputra, which is called the Subansiri. It's a river called the Subansiri, and a dam and a hydropower project in the Subansiri, which is on the border of Arunachal Pradesh and Assam in a place called Dhimaji. So this was a case involving the construction of a hydropower project. And the clause, ladies and gentlemen, in this case, BGS, SGS, SOMA versus NHPC said that the arbitration proceedings shall be held in New Delhi / Faridabad, India. It did not say anything else. It didn't talk about seat of arbitration. It didn't talk about venue of arbitration. And to add to the mystery, it had a floating seat of arbitration insofar as there was a reference to New Delhi as well as Faridabad as the place for the arbitration proceedings. And this case is very important, ladies and gentlemen, not only because it traces the entire history of this seat versus venue debate, but it also, in my view, lays down what I called the three-pronged test, or the no other significant contrary indicator test. Well, this is all my, this is something which I have coined myself. You probably will not find the two tests named such in any textbook as such. But this is what I think. So that's why it's important, because it lays down this no other significant contrary indicator test. And ladies and gentlemen, what is this three-pronged no other significant indicator test? As usual, when you have Justice Rohinton Nariman on the three-judge bench and the matter relates to arbitration, you can be sure that the decision probably will be written by him. And in his inimitable style, he lays down the three-pronged step as follows. And this is very important, because I believe if there was one decision today which probably is the closest to what the law is with respect to seat and venue, and when a venue will be considered to be a seat, it would be this decision, 2019 decision of Justice, penned by Justice Rohinton Nariman. So he says that whenever there is a designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceedings, the expression arbitration proceedings would make it clear that the venue is really the seat of the arbitral proceedings. And the fact that the arbitral proceedings shall be held at a particular venue would also indicate that the parties intended to anchor those arbitral proceedings to a particular place, signifying thereby that that place is a seat of the arbitration proceedings. So this is that first prong, meaning that when there is the use of the word arbitration proceedings, it would make the venue to be the seat of arbitration. And then he goes on to say, the use of the expression arbitration proceedings, coupled with there being no other significant contrary indicia, which stated that the venue is merely a venue and not the seat of arbitral proceedings, would then conclusively show that such a clause designates a seat of the arbitral proceedings and not the venue of the arbitral proceedings. And he again goes on to say, and that in an international context, if a supranational body of rules is to govern the arbitration, this would further be an indicator that the venue so stated would be the seat of arbitration. So ladies and gentlemen, the three-pronged test here in this no other significant contrary indicia test is that use of the word arbitration proceedings, no other significant contrary indicia, and the reference to a supranational body of rules. When these three are existing, then in the absence of a specific mention of the word seat of arbitration, the venue of the arbitration will be considered to be the seat of arbitration. And this was very beautifully captured, succinctly captured in section 6, in para 63 of Justice Rohinton Nariman's decision. And he says, and I will quote because this is very important, it will thus be seen that wherever there is an express designation of a venue and no designation of any alternative place as a seat, combined with a supranatural body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitration proceedings. So, ladies and gentlemen, on the basis of this, in para 100, Justice Rohinton Nariman goes on to say that the seat of arbitration in this case was New Delhi and not Faridabad. The next case, ladies and gentlemen, we need to remember is a line of cases where the venue of an arbitration was not considered to be its seat. Till now, I've been looking at decisions where the venue, in the absence of a specific mention of the seat, was considered to be the seat of arbitration. We're now going to look at a line of decisions where the venue of the arbitration in the absence of a specific mention of the seat, was not held to be the seat of arbitration. And the first decision in this line of cases, ladies and gentlemen, is this case Enercon India Limited versus Enercon Germany. And if you look at the clause, ladies and gentlemen, this was the clause of which led to these arbitration proceedings. All proceedings in such arbitration shall be conducted in English. The venue of the arbitration proceedings shall be London. The arbitrators may, but shall not be obliged to, award cost and reasonable expenses, including reasonable fees of counsel to the parties that substantially prevail on merit. The provisions of the Indian Arbitration and Conciliation Act 1996 shall apply. So, ladies and gentlemen, you will see here that the governing law of the contract was Indian law. The venue of the arbitration was London. There was no mention of the word seat of arbitration, but there was a reference to the fact that the provisions of the Indian Arbitration and Conciliation Act of 1996 would apply to the arbitration. And what did the Supreme Court hold? Now, the Supreme Court held that in the light of the facts and circumstances of this case, it would not be appropriate to read the word venue as the seat. It said that by choosing to apply the Indian Arbitration and Conciliation Act, the parties had made a choice of India as the seat of arbitration. And it further went on to hold that where the seat of arbitration was not specified by the parties, it would have to be determined by analyzing the seat that had the closest and most intimate connection with the dispute. And looking at the facts of the case through the prism of this closest and most intimate connection test, ladies and gentlemen, the Supreme Court came to the conclusion that New Delhi was the seat of arbitration and not London, and London was the mere venue of arbitration. And in applying this closest and most intimate connection test, ladies and gentlemen, the Supreme Court in para 143 said that, and this is how it applied the test. It said that we have earlier noticed that the main contract, the IPLA, is to be performed in India. The law of the contract is a law of India. Neither party is English. One party is Indian, the other is German. The enforcement of the award will be in India. Any interim measures which are to be sought against the assets of the appellant number one ought to be in India, as the assets are situated in India. Then it went on to justify the choice of India as a seat of arbitration by saying that we have also earlier noticed that respondent number one has not only participated in the proceedings in the Daman courts and the Bombay High Court, but has also filed independent proceedings under the Companies Act at Madras and Delhi. All of these factors would indicate that respondent number one does not even consider the Indian courts as an inconvenient forum or forum non-convenience. So, ladies and gentlemen, this is how, in my view, the Supreme Court applied the closest and most intimate connection test and came to the conclusion that India was the seat of arbitration and not London. The next case, ladies and gentlemen, important case, perhaps given the paucity of time, maybe this is the last case I'll discuss, is this case called Union of India versus Hardy Exploration. This is again a case for the proposition that venue of an arbitration in the absence of a seat of arbitration will not be its seat. So let's look at the clause first, ladies and gentlemen. This is a 3-judge bench of the Supreme Court of India. Justices Khanvilkar, Chandrachud, and Mishra. The decision was written by Justice Deepak Mishra. The clause said, the venue of conciliation or arbitration proceedings pursuant to this article, unless the parties otherwise agree, shall be Kuala Lumpur, shall be conducted in the English language. Arbitration proceedings shall be conducted in accordance with the UNCITRAL Model Law on International Commercial Arbitration of 1985. And what did the Supreme Court hold in this case? It held that in the absence of an express choice of seat, and where the seat had not been determined in accordance with the procedure in the arbitration agreement and a venue has been specified, there needed to be an additional factor for that venue to be considered as a juridical seat of the arbitration. Note the difference, ladies and gentlemen, in the test which is given, the significant contrary indicia test stated by Justice Nariman in BGS SGS Soma versus NHPC. And this test I call the additional factor test, because this test says that where seat of arbitration is not mentioned, venue is mentioned, there has to be an additional factor for that venue to be considered as the seat of arbitration. Whereas in the test laid down by Justice Nariman in BGS SGS Soma, it was held that when the venue of arbitration is mentioned, seat is not mentioned, then the venue would be considered to be the seat in the absence of significant contrary indicators that another's place was the seat of arbitration. So you see the difference between the two tests. The additional factor test laid down by Justice Deepak Mishra in Hardy Exploration, and the significant contrary indicia test laid down by Justice Nariman in SGS BGS Soma versus NHPC. So the difficulty, ladies and gentlemen, is this, that now both these decisions are of 3-judge benches of the Supreme Court of India. So which applies? There seem to be significant divergences in the parameters for each test. So what is the law today in India with respect to this? In fact, very interestingly, the Union of India versus Hardy Exploration case was of 2018, whereas Justice Rohinton Nariman's decision of BGS SGS Soma was succeeded the Hardy Exploration case. It was a 2019 decision. And in this decision, interestingly, there has been criticism of the ratio and the test adopted by the Supreme Court in Hardy Exploration. So this is, and the criticism, ladies and gentlemen, is given in para 94 and 96 of the BGS SGS Soma decision. Let's read it. It makes for very interesting reading. So Justice Rohinton Nariman in BGS SGS Soma says in para 94 that he's criticizing the Hardy Exploration decision. He says by failing to apply the Shashwa principle to the arbitration clause in question, the 3-judge bench in Hardy Exploration has not followed the law as to the determination of a juridical seat, which was laid down by a 5-judge bench of this court in Balco. The result in Hardy Exploration is that a foreign award that would be delivered in Kuala Lumpur would now be liable to be challenged in the courts at Kuala Lumpur and also be challenged in the courts in India under Section 34 of Part 1 of the Arbitration and Conciliation Act. Therefore, ladies and gentlemen, he goes on in 1996 to say that we therefore declare, this is very interesting, we therefore declare that the judgment in Hardy Exploration, which is by another concurrent 3-judge bench of the Supreme Court, being contrary to the 5-judge bench in Balco, cannot be considered to be good law. So rather, with the greatest of respect, rather than referring the matter to a larger bench, this decision went on to hold that this Hardy Exploration is not good law anymore. But ladies and gentlemen, the slight difficulty I have is that SGS BGS Soma is a 3-judge bench. Hardy Exploration is also a 3-judge bench. Whilst I agree with the reasoning that Justice Nariman's decision is more in tune with the international perspective on this issue. Can it be considered? So the question I put to you is this: can it be considered that the law is settled now on this matter? In my view, no, because I think there are two contrary decisions of benches of equal strength of the Supreme Court which hold otherwise. They lay down two different principles and two different tests. And my view is that the law continues to be uncertain until and unless this decision is referred to and decided by a larger bench of the Supreme Court of India. So until then, ladies and gentlemen, I believe that this uncertainty about what are those circumstances in which a venue could be considered as a seat in the absence of a specific reference to the seat of arbitration in your arbitration clause will consider to be a gray area of the law, and it will be slightly unsettled. So, but what we need to understand, ladies and gentlemen, is that whilst this is the current state of play, it would also be important to understand as to how the Supreme Court of India in previous decisions has interpreted Section 20 of the Indian Arbitration and Conciliation Act, which deals with the concept of place and venue of arbitration. Now, this relationship between Section 20 and seat and venue and place of arbitration has been very beautifully brought out by the 5-judge bench of the Supreme Court in Balco and also a 2-judge bench of the Supreme Court in Indus Mobile. In this case, in these two cases, the Supreme Court has very clearly said that the reference to the word place in Section 20, subsection 1 and subsection 2 is a reference to the juridical seat of arbitration, whereas a reference to the word place in Section 20, subsection 3 would be a reference to the venue of arbitration. So in simple words, this is what these two decisions held, ladies and gentlemen. As I told you earlier, the Indian Arbitration and Conciliation Act does not use the term seat of arbitration. It does not use the term venue of arbitration. It only uses the word place of arbitration. So, Balco and Indus Mobile have both clarified that the reference to the word place of arbitration in subsection 1 and subsection 2 of Section 20 is a reference to the seat of arbitration, and the reference to place of arbitration in subsection 3 of Section 20 is a reference to the venue of arbitration. So now, ladies and gentlemen, given this, I think there is a certain amount of clarity as to which portions of Section 20 refer to the seat of arbitration and which portion refers to the venue of arbitration. In my view, prior to Balco and the Indus Mobile decision, there was no clear description as to which part of Section 20 is a reference to seat and which part is a reference to venue. And that is why, ladies and gentlemen, if you read past decisions of the Supreme Court of India, with the greatest of respect to the Supreme Court of India, I believe there has been a lack of understanding as to the real purport and scope of the concepts of place of arbitration, seat of arbitration, and venue of arbitration. But now I think with this clarity, I don't think there is the necessity for any lack of any ambiguity, because I think these two decisions very clearly say that where place is seat and where place is venue. But the ideal solution, ladies and gentlemen, in my view, should be an amendment of the law. The law ought to be amended rather than the Supreme Court interpreting place to mean seat and interpreting seat to be venue. The, the right way or the right solution is actually an amendment of the law by the legislature. And this, ladies and gentlemen, there was a suggestion and recommendation made for the amendment of the law and Section 20 in the 246 report to the Law Commission of India. Now, the 246 report of the Law Commission of India, the report dated the August 2014, which was delivered under the chairmanship of the former Delhi High Court Chief Justice, Justice A.P. Shah, made a recommendation for the insertion of an additional clause in subsection 2, in section 2, subsection 1 of the Arbitration Act, where the term seat of arbitration would be specifically defined, meaning the juridical seat of arbitration. Also, the Law Commission of India in this 246 report recommended that Section 20 ought to be amended. And this, ladies and gentlemen, is what it suggested to the Government of India. These are the suggestions made by the Law Commission of India to the government in its 246 report. It talks about insertion of seat and venue and deletion of the word place to a certain extent to clarify this difference between these two concepts of seat and venue. But sadly, ladies and gentlemen, notwithstanding the recommendation made by the Law Commission of India, these recommendations did not see the light of day either in the 2015 amendments nor in the 2019 amendments. But in my view, I think an amendment of the law would be very, very important to clarify the law, because I think this conceptually, if you look at these concepts of seat and venue of arbitration, I think they're very simple concepts. But because of the use of the word place of arbitration and the slight confusion in the minds of, as to the real purport of this concept of place, somewhere down the line, things have become muddled. But now I honestly believe that by virtue of those decisions, the Balcourt decision and the Indus Mobile decision, I think the real interpretation of the provisions of Section 20 qua place of arbitration now is very clear. But ultimately, ladies and gentlemen, when you look at it from a holistic perspective, you can avoid all of this seat versus venue debate by just being clear when you are drafting your arbitration clause. So if you were to define and clearly, unambiguously define seat of arbitration and venue of arbitration in your arbitration clause, then, you need not resort to these battles where the court has to interpret what is seat, what is venue, what is place. So if you have clarity, you have conceptual clarity on these basic concepts, do specifically incorporate them into your arbitration clause. So if you clearly define what is your seat of arbitration, what is your venue of arbitration, and don't unambiguously define it, then you will not have to go to a court of law to give effect to your arbitration clauses. And that, ladies and gentlemen, in my view, is ultimately a simple solution to the seat versus venue debate. And I'd like to end my presentation by giving you two examples of badly drafted, horribly drafted arbitration clauses in connection with the place of arbitration. This is a very interesting case, ladies and gentlemen. Lovelock EGR Limited versus Exportless. It's a decision, English High Court decision of 1968 vintage. Short point I'm trying to make is that this is a classic example of how not to draft a seat or venue arbitration clause. Look at what the clause says. It says, any dispute should be referred to arbitration in London, and that any other dispute should be referred to arbitration in Moscow. So how do you give effect to such a clause, ladies and gentlemen? And this is what Lord Denning, Master of Rolls, who penned this decision, had to say. And I'll end my presentation with this quote from Lord Denning. He says, and I quote, "I am forced to the conclusion that the clause is uncertain and that the court cannot give effect to it. It is beyond the wit of man, or at any rate beyond my wit, to say which dispute comes within which part of the clause." So, ladies and gentlemen, on that warning and the request that you pay a lot of attention to how you draft your arbitration clauses, I would like to end my presentation. And once again, thank you for your patience and time for making it to this webinar and hearing me out actually with respect to my views on the seat versus venue debate. And once again, at the cost of repetition, thank you, Vikas Chatrat and Beyond Law CLC, for your kind invitation. So if there are any questions, I'll be very happy to take them. I think I've way extended my time, so I think we can keep the question and answer session perhaps pretty short.
Yeah. We have few questions, but as...
Yes, Vikas.
Yeah, I'm just checking. I will be unmuting Pankaj Patel. He wants to ask a question directly. I suppose Pankaj Patel is that who is also on the Arbitration India group. Pankaj Patel.
Hi Ajay, how are you? Pankaj here.
All good, Pankaj.
Yeah, Ajay, I think very interesting things. I know you presently, actually, I'm working on that. Basically, if the seat of an arbitration, clearly it says that, it is in India, irrespective of the rules, wherever it is applying, then in case if suppose somebody has to make an appeal against the award, where he has to go, whether to that country which governs the process or whether the country where the seat lies.
So the short point or the short answer to your question is that your appeal or your application to challenge an award will go to the court of the seat of arbitration. If your
Correct.
seat of arbitration is India or it's New Delhi, then your challenge application will go to the Delhi High Court.
Correct.
Notwithstanding that your arbitration is under the SIAC rules. So you might have an arbitration under the SIAC rules, but if the seat has been expressly mentioned to be India in your arbitration clause, then there is no question of going to the Singaporean courts to challenge the award, because your lex arbitri would be the Indian Arbitration and Conciliation Act, and your seat would be the law. Your seat would be New Delhi, India. I hope that clarifies, Pankaj.
Yeah, it's qualified. One more connected question with that.
Yes.
What is happening now? Basically, irrespective, you are saying that basically, if the seat of an arbitration is in India, then the Indian law will apply. And here it is also specifically mentioned that seat of an arbitration is in India. Here, for an enforcement, in spite of coming to an Indian court for an enforcement, if somebody is still flagging off and say that the arbitrations which has been award which has been passed by the foreign institutions binding to the non-signatory, how far it is true? Because non-signatory, he is trying to claim for the party through, that is the provision which has came, the third party who is claiming through that arbitration. So for a non-signatory also, they said it is binding. Even if it is not enforcing that arbitration against the signatory party, for a non-signatory also it is making it binding. How far it is applicable?
So that to a large extent would depend on the jurisdiction where you are trying to enforce the award, whether and also you will also look you'll also have to look at the law of the law of the seat of arbitration and see whether under the law of the seat of arbitration whether an arbitrator's award can bind non-signatories or not. So that answer to a large extent depends on two, in my view, it depends on first as to what is the law at the court of seat of arbitration, and if for example that could also probably be a factor on which you can challenge the award. Secondly, it can also be a factor on which you can refuse or challenge the or make a prayer for refusal of the enforcement of award in the jurisdiction where you go to enforce, because under that at that jurisdiction where you're going to enforce an award, the it would be against public policy for an award to be binding third parties. So that to a large extent depends on where these two jurisdictions are, and you will have to look at what the local law states.
Yeah, I will speak to you in detail because there are many other questions.
Sure.
Thank you. Thanks for your answer.
Though one of the person has gone, but he has suggested, or I can say ask question. This is by Raka. Instead of this word seat, can we simply say that the court at a particular place will have a supervisory jurisdiction?
Well, I think that's perfectly fine, Vikas, because at the end of the day, when you are saying that the court of a particular jurisdiction shall have supervisory jurisdiction of the arbitration, it is a direct reference to the seat of arbitration. Because what does seat do? Seat is effectively determines which courts can have supervisory jurisdiction over the arbitration. So you can very well do that. But my suggestion is that rather than using that, please use the word seat of arbitration. I think in one word, in four alphabets, it very clearly clarifies, what parties want.
Yeah. And he says in the future, venue will be mostly online. So would this venue problem arise subsequently?
No, I don't think venue would really matter, because in that case, because venue, as we have seen, venue is only a reference to is a physical concept. It has no, as a general rule, the choice of a venue in the presence of a seat has got no legal implications. But venue would have some legal implications in those cases where seat of arbitration is not specifically mentioned.
Yeah.
So it'll be interesting to see. It'll be very interesting to see as to how this pans out now. As to would people now say venue of arbitration will be online? I very much doubt they would do that, because at the end of the day, online, whilst yes, it is a venue, but I think when you're using the term venue, you're probably looking at it from a physical venue perspective. I'm yet to see a decision where the court has interpreted an online venue in the absence of a seat of arbitration, but it'll be very interesting. I think the day will not be too far away when you will find in-house counsel drafting clauses where the venue seat is mentioned as Delhi and probably venue is online, or seat is not mentioned at all, merely venue is mentioned. And then how will the seat of arbitration be determined in that circumstance? But that answer to that, Vikas, I think is also very clearly given in Section 20. If you were to look at the provisions of Section 20, subsection 2 very clearly says that failing any agreement of the parties to agree on the place of arbitration, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. So when your venue is online and seat is not mentioned in your arbitration clause, then the provisions of Section 20, subsection 2 will come into play, and the liberty will be given to the arbitral tribunal to decide the seat of arbitration. So I think that is there. I don't think there is any ambiguity. Only thing, it will be interesting to see, on what are the different grounds on which an arbitrator will decide a Section 20 subsection 2 issue.
Yeah, we have unmuted Yajur Bhalla. You would like to ask a question?
Yes,
Yajur?
sir. Hi, sir. How are you?
Yes,
Sir,
sure.
I almost had the same question in the context of COVID, when the seat of the arbitration is Delhi. One arbitrator is sitting in, Jaipur, one is in Bombay, and another is in Jaipur. Now, how do we, figure out what is the seat or the venue going to be in such a situation when everybody is spread, the claimants somewhere in Punjab, one is in Haryana? It's very difficult to ascertain what the seat or the venue would be in this.
Yeah, so I think I've answered the question, isn't it, Yajur?
Yeah.
So
Yeah, so thank you, Ajay, and it was nice connecting with you, and you have actually put the things in the right perspective as to how the law has developed and what should be taken forward, and especially when you had also taken reference of the Law Commission reports, etc. And I think the gray areas, whatever it would be, taking cue from such webinars, one can expect that those gray areas would be actually be over. And tomorrow, friends, we would be having a perspective on Section 156 of the CRPC by Justice RB Budial from Karnataka High Court. Do stay connected with us at 5 p.m. And before we are parting, Dr. Shrikant wants to ask a question. Dr. Shrikant, unmute.
It is not a question, Vikas ji. It is more of a submission. I think Ajay would also, when he surmised at the end of the presentation, he put it very well that we still have ambiguity with regard to seat and venue. I think the business of the courts is not to be in the business of the business. So without putting it more ambiguous.
Shrikant, unmute. Shrikant, you will have to unmute yourself. You have muted yourself. Though you are not on the video, but you have also unmuted yourself.
Oh, I'm so sorry. Where did I? So I was saying the business of the court should not be to be in the business of the business. I firmly believe that the court should not interfere in party autonomy. That is the fundamental premise of arbitration. And as a matter of fact, only 2 days back, the ICC chair held an award against a very popular rap singer, and that was held again in a court for the singer or for that particular rapper as such. So I think the courts are interfering too much. And as a matter of fact, parallelly, as we happen to speak in this webinar, there is a PCA webinar which is going on in which Justice Nariman and his father is also speaking about the same issue.
thank you, Shrikant. I can't agree more with you that I think it's the business of the business to be doing business, and it is not the business of businesses to be indulging in in disputes. But then I think all the lawyers, the litigating lawyers in this room, probably this virtual room, will beg to differ, because I think as long as there is ambiguity in the law, I think that would mean good business for lawyers and law firms.
Yeah, that's true. So thank you to all the participants who are watching us live on the Facebook, Instagram, and YouTube, as well as on this platform. And above all, to Ajay, who has shared his knowledge. And if you could share the PPTs, we will share it in the groups. Thank you to all the participants once again. Everyone, stay safe, stay blessed. Jai Hind. And we will connect tomorrow at 5 p.m.